Criticism was also levied at the old regime's failure to sufficiently protect investors, allowing laid-off workers, for example, to be paid before creditors. The new law, however, states that secured assets will belong to secured creditors, leaving behind the government's previous concerns over avoiding provoking social unrest. One caveat to the position of secured creditors, however, lies in the provisions regarding debt haircuts in the new regime. Common, secured, and public debts are now all potential sources of reduced valuation trimmings to forgive debts. Over time, Hess remarks, this will probably lead to a practice of private out-of-court loan workouts with banks, a common practice in Western jurisdictions which does not yet exist in China. Wholly foreign-owned enterprises will benefit from the public haircut provisions in an important way, remarks Hess, since there is no limitation of action against the debtor of taxes and mandatory contributions to the Chinese social insurance system. Immediately after the promulgation of the bankruptcy law, an interesting restructuring proposal by Beijing Shangzhou Reproduction Health Center came to the attention of practitioners. The hospital was founded in August 2004 with a registered capital of 10 million renminbi, but quickly deteriorated due to mismanagement. At the time the hospital filed for bankruptcy in October 2006, it faced 45 creditors with claims. The hospital filed its restructuring proposal in late April 2007. And despite the fact that the bankruptcy law would only become effective in June of that year, was implemented with close reference to the newly promulgated regime. The creditors' meeting, for example, passed the restructuring plan with the majority of all voting classes as required under the new law, and the purchasers were able to impose certain conditions for investment, such as an agreement with creditors for. As such, practitioners see the case as the first instance of restructuring procedures in China under the new law. It constitutes a well-known and educative example of the combination of formal restructuring procedures and a buyout by a new investor who is willing to invest fresh capital in an insolvent company, Hess points out, citing the wide interest expressed by legal circles. But Hess concludes that at least part of the reason negotiations were successful lie in the nature of the business in question. Shangzhou Hospital was an interesting target for potential buyers because it held an otherwise non-transferable hospital operation. While the new law sets out a well-drafted set of protections for foreign investors, practitioners admit there are inadequacies that remain unaddressed. Many issues in questions have been addressed in principle, but in many aspects, there also remains a lack of detailed rules and guidance for implementation of the new law, affirms. To its credit, the PRC has announced that it will address the major points of confusion with a special interpretation expected to be promulgated by the end of the year. In the meantime, concerns remain about the fact that Chinese courts do not adhere to a system of precedent. The courts have wide discretion how to implement the new law, Hess concurs. Furthermore, in the PRC, precedence is not binding upon subordinate courts. It can therefore be expected that there will be considerable inconsistencies during the first years of implementation of the bankruptcy law. As in Hong Kong, The position of employees in restructuring and liquidation of failing companies presented major challenges to the drafters of the new legislation. The provisions of the employment contract law have come to the aid of such workers, with Article 19 providing that entities undergoing restructuring in accordance with the new legislation cannot terminate employment contracts. Hess calls the provision a welcome clarification of existing legal provisions for mass layoff under the PRC employment contract law. The PRC employment contract law and its implementing regulation provide for a stronger protection of employees, he continues. This adds to rising labor costs, which is one of the economic factors, such as spiraling raw material prices and appreciation of the Chinese yuan, that currently distress FIEs. Protection of distressed companies against enforcement of claims and securities of their debtors in order to rescue the company from liquidation is a concept which is entirely new to the Chinese legal system, Hess explains. It is notable in this regard that despite its efforts to modernize proceedings, no move has been made to establish dedicated bankruptcy courts in the country. Concerns also remain that the unique legal and administrative environment of the PRC will create further issues in implementation. In order to ensure the success of restructuring proceedings in China, stakeholders that may play only a limited role in Western jurisdictions, such as the local government and Communist Party leaders, have to be involved in an appropriate way at a very early stage of the proceedings, maintains Hess. As the United States is the number one trade partner and top export destination, China is by no means immune from experiencing the ramifications of the decline in American spending power. But the more certainty the outcomes of the implementation of the new legal framework can provide, the more assured investors will be that their assets are well placed in the first place.